So good morning, and thank you very much for joining us today. My name is Giorno. I'm joined by my colleague Kyle Morrow, and together we're going to be presenting this interactive webinar on federal election, that is Canadian federal election compliance for businesses and organizations. We expect to take about an hour, leave room for questions, which you can put in the chat. We also have some questions that people sent along at the time they registered. We'll try to address those as well. So I wanted to thank you first for taking time out of your days to be with us. It's an interesting time, a lot of developments in Canada, and it's obviously of significance to businesses and organizations and people who deal with government and people in government and political parties who are interested in making sure that their activities are fully compliant with the law. I should begin by noting that this is an informational session. We're not providing legal advice. Obviously, if you have a particular request to understand how the law applies to a particular fact situation that affects you or your business or your organization, that's something that we or other lawyers can help you with. But as an audience for the seminar, we're simply providing general information about how these federal rules apply to you. I thought next I'd just sort of give an overview of what Kyle and I will be talking about over the next hour and a bit. I'm going to begin with some context setting, talk about just elections, how they occur, how Parliament result in the formation of governments. Then we're going to talk about how lobbying law and the act of lobbying is affected by the dissolution of Parliament and election, formation of a new Parliament. We're going to talk about how to ensure that your organizations, people who work for your organizations, avoid unlawful campaign contributions. Kyle is going to spend a lot of time talking about the rules that apply to nonpartisan actors. So that anybody who's not a political party or a candidate or a worker for a candidate is considered a third party. And there are rules during an election campaign which apply to you and your organizations, your companies. If you engage in certain activities, Kyle's going to talk about that. And then we're going to wrap up just with some comments on how to take a due diligence approach to protect yourselves, protect your companies and organizations during this time. So to begin with a bit of context, we not just expect, we know that by law there will be a federal general election this year. It is definitely going to happen by October 20th of this year, but all indications are, news media commentary, or leaks from government suggests that we could be an election campaign much sooner than that. So Canadian federal law, like the law of all the provinces, actually provides for regular 4-year intervals. And the legislation says that federal elections will be held on the third Monday in October. So the legislated date in 2025 will be Monday, October the 20th. Now, there was legislation before Parliament which would have moved the election date for this year only 7 days forward to October 27th. When Parliament was prorogued, that legislation died. It was in the middle. It was had only passed second reading. It was before a committee of the House of Commons. The committee was, at the time of prorogation, debating that very section and an amendment which would have removed the provision which would have moved the election date from October 20th to 27th. So right now, still in the books, October 20th is the legislated date. However, the 4-year legislation does not remove the authority of the Governor General, who in these matters will only act, or by convention will only act, on the advice of our Prime Minister to dissolve Parliament and call an election at any time. Known as a snap election. Snap election isn't just a Canadian term, it's actually an internationally recognized term for an election which occurs out of a sort of an ordinary cycle. If there is a snap election, the timing requirements of the Canada Elections Act still apply, namely that voting day, election day, polling day, all terms we can use interchangeably, will take place on a Monday, unless Monday's a holiday, in which case the election will be on a Tuesday. The dissolution of Parliament coincides with another action, and that is the issuance of a document called a writ of election, which goes to the returning officer in each district or each riding and essentially tells the returning officer in that district to conduct an election to return a member of the House of Commons in that district. So when Parliament's dissolved, election writs are issued to all the returning officers across the country. The timing of that act determines the range or the possible range of voting days. Voting day must be no less than 36 days after the day on which Parliament's dissolved and the writs of election are issued, and no more than 50 days. So, speaking hypothetically, or maybe not hypothetically, but quite realistically, if Parliament is dissolved and an election is called this weekend, that means, using the elections must be on Monday and 36 to 50 day long period. That means that voting day could be as early as April 28th, which is as recently as today, a date which is being floated in the news media, or could be as late as May 5th or May 12th. All of those are Mondays, and those are the only legislated days, right, them being Mondays, on which an election can take place. Now, an election call dissolves Parliament. It doesn't dissolve our government. Government of Canada continues. Cabinet continues. The ministers in that cabinet continue to hold office, and the Prime Minister continues to hold office as Prime Minister of Canada. I wanted to next just talk about what happens after an election, and that sort of leads into a discussion of what happens during an election campaign. I know there's been a lot of talk, and there's always talk, how many seats do you need to win to form a government, and what happens if this party finishes first and has more seats than another party, and sometimes there is discussion of what should the Governor General do. Actually, in our system, the incumbent Prime Minister remains in the driver's seat after an election. It's a matter of our law that Prime Minister, remains in office until one of three things happen. Until the Prime Minister resigns, which is the way most Prime Ministers in Canadian history have left office. Dies in office. That's happened to several provincial premiers, but it's happened to one Canadian Prime Minister, John Thompson, or is dismissed. So the Governor General does have a power, and lieutenant governors in provinces do have powers to remove first ministers. Dismissal has happened at the provincial level 5 times, 3 times in British Columbia, 3 times in a 5-year period. It's an amazing time in British Columbia history. Twice in the province of Quebec. Most history books will say that Prime Minister, a federal Prime Minister, has never been dismissed by the Governor General, but more recently, and James Bowden has sort of led this new take on history. It's probably correct to say that Charles Tupper was dismissed by the Governor General. His party had lost the 1896 election. The Liberals, under Wilfrid Laurier, won a clear majority of seats. I'd say probably clear majority is not the right word, because in those days it was not entirely sure. There were some people who were loosely affiliated with the Conservative Party or the Liberal Party, but 117 seats out of a 213 seat House of Commons in the June 1896 election, and Tupper refused to resign. And Tupper tried to put through appointments of senators and others, and the Governor General, Lord Aberdeen, said, and sent a lengthy explanation, which is on the historical record, no, I'm not going to do that. 2 days after that, Tupper resigned. So the books say that Tupper resigned after losing an election, but as James Bowden and others point out, essentially he was dismissed, because when a Governor General refuses to act on the advice of a Prime Minister, that's tantamount to dismissal. And so I think the more correct view is that Tupper was dismissed for refusing to respect the results of the 1896 election. Nonetheless, after the 2025 election, Because Mr. Carney is the prime minister, it will be up to him to decide what to do next. Whether he has more seats or less seats than another party, he's entitled to continue in office. And not just entitled to, he is the prime minister and continues in office until he resigns. Now, if another party has a clear majority of seats in the House of Commons, then by convention, resignation is the appropriate outcome. And as Charles Tupper found, if an incumbent prime minister refuses to resign in the face of majority victory for the opposing party, dismissal is an appropriate outcome. But other than that, it is up to a prime minister in a minority parliament to decide to resign, to which would let the Governor General call on somebody else to form a government, or to face Parliament. Now, there is another part of our Constitutional Convention, and that is that while the timing of the return of the House of Commons is in the hands of the Governor General, acting on the advice of the Prime Minister, there is a Constitutional Convention that, particularly in a minority situation, a Prime Minister should present his government, his ministry, to the House of Commons at the earliest opportunity, which would give the House of Commons the ability to determine whether or not that's a ministry, a government which has its confidence. And at all times during its life, the ministry, the cabinet, must maintain the confidence of a majority of the House of Commons. Confidence expressed either by negating a motion of non-confidence or confidence expressed by affirmatively supporting an instrument or a measure which is understood by convention to be a matter of confidence. Vote on the throne speech, vote on the address and reply to the throne speech, vote on the budget measures, for example. This leads then to a constitutional convention known as the Caretaker Convention. Conventions should be understood it's what they are. But some people say, well, the Constitution is not a law, it's voluntary, it's not. Well, constitutional conventions are not legally documented like in the Constitution Act or in legislation, but they're nonetheless unwritten understandings about how government and officials are to operate. And to that extent, they are of constitutional weight because these unwritten understandings are assumptions based on which our system of government operates and continues. So it's put differently, conventions aren't optional. They are required actions. The Caretaker Convention is designed to balance two propositions. One proposition being that even though Parliament is dissolved, the government continues. Canada always has a government. Whether we're in an election or not an election, there is always a government which is able to govern. Balances that consideration with the fact that in an election campaign, the people of Canada are about to decide who will populate the new House of Commons. And that House of Commons will determine ultimately, indirectly, who is going to govern the country. It's understood that during that period of time, it is inappropriate and unfair either for an incumbent government to use the tools of government to partisan advantage, and also unfair for an incumbent government to do things which will tie the hands of a future government in a way that actually makes the compromise or makes the election meaningless. So the Caretaker Convention, as it's called, balances those two equally important considerations. It applies to the entire government. So both the ministers of the crown who hold office in the government and the public servants who are employed by the government. When does it start? It doesn't start now. I know there's a lot of discussion. Well, minority, Prime Minister Carney doesn't have a seat in the House of Commons, never at the House of Commons, should be restricted. But reality, he's got full powers as Prime Minister until Parliament is dissolved and the Caretaker Convention kicks in. How long does it continue? It continues either until if there's going to be a change of government, the new prime minister and the new prime minister's cabinet are sworn in, or as soon as the election results make clear that the incumbent will continue to be the prime minister. So, for example, if the Liberals are reelected, even with a majority of some kind, and it's clear that Mr. Carney will continue as prime minister. The caretaker convention ends at that point. It doesn't continue until the date he swears in a new ministry is sworn in. And at that point, I should add, by the way, that ministers come and go and hold office at the pleasure of the prime minister, who advises the governor general. But a prime minister's term, as I've said, continues until the prime minister resigns or dies in office or is dismissed. So prime ministers don't have to be sworn in again after an election. If they do so, they choose to be resworn, that's only a matter of optics. And they're entitled to do that as a matter of optics. I don't even know, for example, yesterday whether Premier Doug Ford in Ontario was sworn in again as his ministers were sworn in. But an incumbent prime minister does not need to be sworn in again because the prime minister is not starting a new term as prime minister. The prime minister's ministry is continuing. But ministers obviously can come and go and be sworn in, or if they change portfolios. And if a new prime minister and ministry are taking over, then obviously they're all sworn in. So that's when the caretaker convention applies. Now, the caretaker convention is not meant to interrupt the ordinary operation of government. Think of all the things the government of Canada does. It would be untenable and not in the public interest to have passports not issued, or not to have customs officials stop passengers at the border and question them. Taxes need to be collected. All the things that government does. There are we've got a transportation safety board, which is looking at that. We've got food inspection. We've got public health measures. I mean, all those operations of government one would want to continue whether or not there's an election. However, areas of expenditure, making of new policies, cabinet's ability to make laws, regulations, which it can do without going to Parliament, appointing people to positions. All of those are the sorts of actions where the need to ensure that a new government's hands aren't tied, the need to ensure that the election's not undermined by taking away from Canadians the right to have a say in what happens before it actually happens, outweighs routine business of government. So switch to the next slide. In these areas, particularly expenditures and policy and making of regulations and orders and appointing people, the understanding is that the government must act with restraint. Do things that are non-controversial, that's fine. Do things that are routine, that's fine. In an emergency, absolutely deal with something that's urgent and a matter of public interest, or it's open to a prime minister to consult with the heads of other major parties. But outside those areas, there shouldn't be new spending. There shouldn't be significant contracts. There shouldn't be new policies made or decisions made or appointments made. And this applies not just to the ministers who have to act with restraint, but also applies to the civil servants. They are not going to be awarding non-routine contracts or grants or contributions. I mean, routine ones, obviously, payments to Canadians, things like that would continue. They're not likely to be consulting stakeholders on new developments, and they're not likely to be developing or implementing new policies. So that has an impact. Why would we spend some time on this? That has an impact on people who are interacting with the government. It is not fair to say the government shuts down, because Government of Canada will continue. But it does mean that a lot of interaction between the private sector and the non-governmental sector and the Government of Canada will kind of be put on ice or parked for that period of time. Caretaker convention is also closely linked to the imperative that government resources and government positions can't be used to benefit a party in an election campaign. Now, don't get me wrong. Government resources can't be used for partisan activity outside elections either, but there's a heightened sensitivity to this imperative during election campaign. Deputy ministers and heads of agencies have a responsibility to ensure I mean, at all times, particularly during an election time, that their resources of the agencies, the departments are not used partisan purposes. And ministers are supposed to avoid high profile activities. And federal guidance on the caretaker convention singles out federal, provincial, territorial meetings, international trips, high profile announcements. So that also is a factor that will govern or limit or restrain the activity of both the political side and the non-political side of government during this period of time. I wanted to make that a basis for the next uh, part of our session. We talked about the impact of lobbying law on election campaigns. So lobbying law is a federal law, and it continues to operate during a general election. There's no doubt that it exists. There are some changes not to the lobbying law, but to people under the law that are affected by election campaign. The first being that members of parliament are no longer members of parliament. With this on dissolution, they're not. Um, they are simply candidates, or in some cases, they may not even be candidates. They may simply be former members of parliament who are not seeking re-election. Senators, on the other hand, remain public office holders. Ministers, while they cease to be MPs, once parliament is dissolved and the election is triggered, remain public office holders because they remain ministers. As I've said, the caretaker convention restrains the ability of the prime minister and the ministers to act during that period of time, but it does not remove their status as public office holders. So what does that mean for a lobbying perspective? Communications with ministers and the prime ministers, if they otherwise meet the elements of lobbying, I'll get to in a second, are lobbying communications. What's a lobbying communication? Lobbying under federal law is a communication either that an employee is engaged in on behalf of an employer, or that a consultant is engaged in on behalf of a client, or that a member of a board of directors, a business board of directors, is engaged in on behalf of the company on whose board the director sits. Communication by any of those people with a public office holder that is about, is in the law says in respect of. So it's in respect of, or it's about any of a list of enumerated categories of decision. That includes the development of legislation, the making of a regulation, the development of laws, otherwise, or policies of the government of Canada, the awarding of grants, contributions, or financial benefits, and for two categories of people talking, and that is consultants who are communicating on behalf of clients and members of boards of directors of businesses who are communicating about the interests of their businesses or the businesses on whose boards they sit. A communication about the awarding of a contract from a federal contract is also a lobbying communication. And arranging a meeting between somebody else and a public office holder is also a lobbying communication. Now, as we talk about people who are public officers and who aren't, it's important to remember that unless they quit, people who are employees of the House of Commons or of the Senate of Canada or of a government department or agency, and that includes people who work in ministers' offices, remain public office holders. Now, if they're actively campaigning, they should either A, be doing it on their own time, or B, be taking a leave of absence and therefore doing it on their own time. But a government official, a government employee, a minister's office employee, we talk about a political staff member, or a House of Commons employee, use that example, even on a leave of absence is still employed, right? People on leaves are still employees. And people who are employees of ministers' offices and employees of the House of Commons remain public office holders. So for the rest of the world, what that means is there is still the possibility that you could be having lobbying communications. And I want to give a very practical example. There will be in every election, right? There are people who have business interests. There are people whose day jobs involve lobbying. There are people who work for companies and organizations that deal with the government of Canada, all of whom will be, during the election campaign, actively participating and campaigning and helping politicians, candidates of their choice. They may, you may, if you're, if that applies to you and you're watching the seminar, you may be campaigning alongside somebody who is a political staff member on a leave of absence. And you've got to remember that as you door knock together or put up signs together or do whatever you do in the campaign together, your communications, if they otherwise meet the definition of they otherwise would constitute lobbying, are regulated communications. The Lobbying Act applies to them. They must be reported if they are designated public office holder communications, as you would normally report them. Otherwise, they must be captured by the registration, as any communication that's a lobbying communication with a public office holder must be captured by the registration. And the Lobbyist Code of Conduct, which we're going to talk about, also continues to apply to you. I'll talk about that now. Canada's a democracy. Everyone has the democratic right to be a candidate for office and to work for, to help candidate of choice. So nothing in lobbying law removes the freedom of a lobbyist to participate in the political process in that way. What the Lobbyist Code of Conduct does is to attach consequences to someone who helps a politician get elected and then wishes to or proposes to lobby that successful candidate or the staff of that successful candidate or people in the office of that successful candidate. So this is not a new restriction. It is something that has been in the Lobbyist Code of Conduct for some time. What happened in 2023 was the Lobbyist Code of Conduct was rewritten to bring clarity to this restriction. But the underlying restriction or restriction, I guess I call it, prohibition is unchanged. And the basic unchanged prohibition is that after you help someone get elected, if you propose to lobby that person or the staff of that person, you got to wait for a period of time. Cooling off period is sort of an informal but popular term to describe that. You've got to wait a period of time, and the purpose of that period of waiting, that cooling off period, is to allow the unfairness to diminish. Put differently, because this is sort of the technical explanation of what I mean by unfairness. The assumption behind the rule is that when people help politicians get elected, the politicians feel they owe those helpers. They feel a sense of obligation. And the purpose of the cooling off period is to allow that sense of obligation to dissipate. And after that is dissipated, after a sufficient amount of time has passed, it is then acceptable for the individual who helped the person get elected to lobby. Now, how long? Well, here is where the law has changed, or the rule has changed over the last 2 decades. At the time when it was a 4-year prohibition. More recently, that's been reduced to 2 years, and now the Commissioner of Lobby says, well, it's a cooling off period, which won't be more than 24 months, more than 2 years, but it could be as low as 12 months or a different amount, depending on what it is that you've done. And in a moment, I'm going to talk about what it is you might do for a candidate and how that works. As I've said, it's also important to note that this prohibition extends not just to the politician, but people in the politician's office. So, person, a member of parliament, people, members of the MP's office, if the person's a minister, people in the minister's office. Also, because parliamentary secretaries are appointed to assist ministers, it also restricts the parliamentary secretary and people in the office of the parliamentary secretary. So, the next slide presents more detailed guidance, which is given by the Commissioner of Lobbying of Canada looks at what is it that somebody does for a politician and how does that affect the cooling off period. Some things, in the eyes of the, and I think correctly, in the eyes of the Commissioner of Lobbying, some things are so significant. Um, the assumption that a politician is going to feel obliged, feel that the politician owes something to the person who helped is very strong. Will last for a long time before that sense of owing the person who helped on the campaign will dissipate. Now, for example, campaign manager, somebody who raises money, not gives money, but raises money. And now, a few of these you can take or leave, but based on your own experience. But sorry, you can um, choose to agree or disagree with how strongly politicians feel obligated to these individuals. But you can't take or leave the fact the Office of Commissioner of Lobbying says that these rules are going to lead to a 24-month ban. And that is sitting on the board or the executive of a riding association or electoral district association. Again, you may agree or disagree with how significantly MPs feel about people who sit on their riding executives. But the Commissioner of Lobbying, assumes that MPs feel strongly enough about that that people who do that ought not to lobby the member of Parliament for 24 months after leaving the riding executive or the riding board. Preparing people for debates as well. We can agree or disagree about how strongly candidates feel about people who help them with debate prep, but in the eyes of the Commissioner of Lobbying, it is presumed that candidates feel strongly enough about people who help them with debate prep that there's a 24-month lobbying restriction. Other actions will result in smaller cooling off periods, canvassing, simply seeking donations as opposed to organizing fundraising events. I apologize if I said that raising money triggers a 24-month ban. Organizing a fundraising event triggers a 24-month prohibition. Just collecting donations or soliciting contributions will trigger a 12-month ban. And other roles may be subject to a lesser ban. Some things, next slide, don't lead to prohibitions at all. Exercising your democratic right to make a contribution or attend an event or putting up a lawn sign or putting on your social media profile that you're supporting this candidate. None of that is likely to trigger the cooling off period. Final thing I wanted to talk about is unlawful contributions. Just a reminder that Canadian federal law, like the law of not all, but almost all provinces and territories, provides that only human beings, only individual human persons can make political contributions. They must do so with their own resources. So that's the positive way of saying it. The flip side, the prohibition then, or the negative consequence is that if only individual human persons using their own funds can make contributions, it means that any other entity is acting unlawfully if it is contributing to a candidate, a political party, a nomination contestant, a leadership contestant, etc. And when I say contributions, I'm referring not just to contributions of money, but contributions of anything of value, of a good or service. So why this is important then from an organizational perspective or a business perspective is organizations, businesses, trade unions by definition can't contribute. If any resources belonging to one of those entities is sent, is used, is diverted to support a party or a candidate or nomination contestant, etc., that is by definition unlawful. So what does a employer, what does an organization, what should you be doing inside your own businesses and organizations? You should make sure that all the resources of the company or of the organization um, are not in any way, shape, or form used to help parties or candidates. When I say anything, a boardroom, anything in your property, the outside of your property, the inside of your property, your IT system, your hardware, employees' cell phones, employees' laptops, if they're not employed, if they belong to the company, and paid time. One of the is paid time, right? The time which employees are paid to do work for the company or organization is a resource. It's a thing of value. It belongs to the company or organization. Companies and organizations can't make contributions. And therefore, if employees' paid time is used to help a political party or candidate, then an unlawful contribution results. You might say, well, wait a minute, what if we don't know? Well, this is actually why organizations and companies, I'll get back to this at the end of the presentation, we talk about due diligence, have an obligation to make sure that rules are in place, policies are in place, notices go out, and there's monitoring to ensure that company time, company property is not used to benefit parties and candidates. So I think, Kyle, I'm going to pass over to you now.
All right. Well, thanks, Guy. And thanks again, everyone, for joining. So I want to spend a little bit of time now just talking about the federal third-party election rules. So Guy has discussed kind of the political context from the view of political parties and public office holders. What about businesses and organizations who want to engage in advertising or activities during the election? What are the rules around that? Before I outline what's regulated and what's not regulated, I just want to start by highlighting some of the legal risks associated with non-compliance. So the first point on the enforcement side is that there's a series of proceedings by which the Canada Elections Act can be enforced. There's administrative proceedings, which are conducted by the Office of the Commissioner of Canada Elections, which is adjacent to, but not to be confused with, Elections Canada. The commissioner has very broad investigatory powers, almost judge-like powers, for example, to seize documents, to compel testimony, etc. They can conduct an investigation in that context in their office, and they essentially, for lack of a better term, act as the investigator, the judge, and the jury. There's also an option to proceed by way of a prosecution, which is a formal court-based process. It's a criminal process. It carries with it hefty fines, including the potential for incarceration. So there's a hypothetical for both, but not both of those proceedings to be used to enforce the Canada Elections Act. The other somewhat slightly related proceeding, which I just flagged, and those of you that follow politics closely will be aware of this, but we've seen, especially in a minority context at the federal level, an increased weaponization of parliamentary standing committees. And those standing committees have very broad investigatory powers. And so oftentimes what you'll see in a minority situation is while there's an investigation going on by an officer of parliament, the lobbying commissioner, the Office of the Commissioner of Canada Elections, etc., there are also sometimes simultaneous parliamentary investigations going on. And so that's a big reputational and political risk. Parliamentary committees don't have the ability to impose the penalties that the courts and the officers of parliament, such as the Office of the Commissioner of Canada Election, do, but they can obviously garner a great deal of attention, and those proceedings are, of course, televised, as those of you who watch CPAC or watch the online parliamentary website are aware of. What are the maximum penalties for non-compliance with the Canada Elections Act, and more specifically with the rules that regulate federal activities and advertising for third parties? There's a hypothetical incarceration time for an individual of up to 5 years. There have been individuals who have been sentenced to prison for violating various provisions in the Canada Elections Act. There's also a potential for a fine of up to $100,000 per offense for an organization or business, as well as fines against individuals. And in the event that you as a third party overspend, you spend over the limits, which we'll talk about in just a few slides, there's also an additional penalty of up to 5 times the amount of the overspending. So that's kind of why it's important to have a due diligence system in place, why it's important to understand these rules, and what can happen if something goes wrong. Maybe just to back up a bit, what exactly is a third party? I kind of mentioned this at the outset, but it's generally any person, an individual or group, corporation, organization, not-for-profit, that wants to participate in or influence an election. And obviously, it excludes political parties, EDAs, or riding associations, as they're sometimes known, and all other political actors, those running for nominations, those running for the leadership of parties, and of course, candidates themselves. So when are activities and advertising by federal third parties regulated? And Guy outlined how we don't know exactly when the next election is going to happen, but we know it's coming this year. If we proceed to the fixed election date in October, there will be a pre-election period that will start in on June 30th. That pre-election period will run until the election is called, sometime around early September. And again, as Guy mentioned, there's some flexibility on the length of a campaign period. So if we go to the fixed election date in the fall, there will be a pre-election period followed by an election period which will commence sometime around the beginning of September. I think most of the rumor mill around Ottawa is suggesting, the leaks, all of that, as Guy mentioned earlier, that we're likely heading towards an early election. In the event that we head to an early election before October of this year, there will of course be no pre-election period, and we will be in a regulated period the moment the election is called. So if the election is in fact called this Sunday, as many are speculating in the media, the regulated period for third-party election activities will start on Sunday, and it will proceed until election day. And Guy highlighted those 3 days where there could be a potential election. There, of course, will be no pre-election period because in the event of a snap election, you don't have time to plan in advance and you don't know when the election is going to be called. So again, the regulated period will depend on when exactly the election is called and whether we go to the fixed election date. What are the spending limits? So I'm going to talk about in the coming slides what's regulated, but these are the spending limits that apply to third parties. So during an election period, so again, that's from the date the election is called until the final polling day or final election day, the spending limit is $602,000 and change at the national level and $5,000 and change at the riding level or in each electoral district association, as they're sometimes called. If we go to a fixed election date, starting on June 30th, there will also be a spending limit for the pre-election period, and those figures are listed on the left-hand side of the slide there. Again, there's a riding level spending limit and a national level spending limit. What counts towards that spending limit? It includes your labor costs, so the time spent by your employees designing and deploying advertisements, for example, the costs of existing content. So if you produced radio advertisements, for example, or periodical advertisements in the past and you reuse them during a regulated period, it doesn't matter that they were produced prior to the regulated period. If you use them, you distribute them, you transmit them during the election period, you have to incorporate the total cost of that content. And it also includes any non-monetary contributions you receive. So if someone provides you with goods or services for free or at a reduced below market value, you've received a non-monetary contribution from them, and you have to treat that as well as an expense. So if someone donates $20,000 worth of polling that you use for your regulated activities, you have to account for that as an expense as well. Again, that drops the total amount that you can spend at the national level. It also includes, as I mentioned, some spending before the election, assuming that you use the product that you've produced during the regulated period. One question we commonly get is, are you allowed to use your own funds? And the short answer is yes. provided those funds were obtained from conducting business in Canada or domestic sources. So if you're a corporation carrying on business in Canada, you can use revenues you've generated from business in Canada to fund third-party activities. What you can't do is use revenues that were generated abroad. So if you're a Canadian subsidiary, for example, of an American parent, it's prohibited for that American parent company to transfer funds to the subsidiary and then the subsidiary to use those funds for third-party advertising. So you can use your own funds, the revenues that you've generated from your business activities, but you can't use them if they are tied to a foreign country. Are there limits on the amount that individuals, businesses, or organizations can donate? The answer is no. So you can donate, as long as you're an eligible contributor, as much money as you want to a registered third party. What is an eligible contributor? Well, it's anyone who's an individual citizen or a permanent resident under the Immigration and Citizenship Act, a corporation, organization, or association that carries on business, and it could be commercial or non-commercial in Canada, trade unions. And I've put the last bullet point in italics there because hypothetically, the way the statute is worded, you could use funds from a government that is not a foreign government. But I've put it in italics because while it may be permitted under the Canada Elections Act, it's likely prohibited under the contribution agreements that you've signed with the government. So that's why that's in italics there. So again, there's no limit on contributions, the amount of money that someone can donate, but that person has to be an eligible contributor. And for the third parties, you can't accept ineligible contributions. So you have to return funds, for example, if they come from foreign sources. You can't use them, you can't keep them. There's also restrictions on anonymous contributions. They're prohibited. There's restrictions on cash contributions. They're prohibited if they're over $20. And there's also contributions on using another individual or organization's funds. You can't donate with someone else's money. And this goes to what Guy was speaking about earlier. If you attend a political fundraiser, for example, you can't submit or request that your employer reimburse you for attending that political fundraiser. You're making a political donation with your employer's funds, which is unlawful. So you have to use your own funds. So switching gears a little bit now, what exactly is regulated? So we've talked about the spending limits, we've talked about the contribution limits, we've talked about when third-party activities and advertising are regulated. Well, there's 3 buckets of regulated activities under the Canada Elections Act, and I'll walk through each one of them. The first one's election surveys. The next one is advertising, which in the Act is known as both election and partisan advertising, depending on the particular regulated period you're operating in. And then there's a third category that was added to the Act in or around 2018, which is known as partisan activities. So if you engage in any of these activities and the cost that you've put out to engage in them is more than $500, you're required to register as a third party with Elections Canada. So starting with the first regulated activity, election surveys, also known as polls, they're generally not regulated, but they become regulated if you use them for a specific purpose. So if you've conducted a poll where you're asking Canadians about their voter preferences, who they're supporting, what party they're supporting, what issues they would like to see politicians talk about, any of those things, it's not regulated in and of itself. But it is regulated if you take that poll and you use it to decide or not to decide, or decide against, engaging in regulated activities, or you use it within your activities. You use it to organize, to transmit, to strategize, to carry out your advertising or activities. So polls, again, not generally regulated, but if you use them to decide on whether or not to enter the arena, and you use them in any of the regulated activities, you do need to account for them, and they do become regulated. The second bucket of regulated activities is advertising. And in order to be regulated under the Canada Elections Act, and this is slightly different than some of the provincial statutes that you may or may not be familiar with, there has to be a placement cost. And what is a placement cost? It's essentially the cost you're paying to a publisher, a broadcaster, a social media company to transmit or to distribute your message. So if you purchase an advertisement on a bus shelter, for example, it's the cost that you paid to the company. If you purchase a radio advertisement, it's the cost that you paid to the broadcaster. If you purchase advertisements on X or Facebook or LinkedIn or any other social media, it's the cost that you paid that social media company. Okay, so it has to have a placement cost to fall into this category. There are some situations in the next, the third party partisan activity category that don't require a placement cost, but for the purpose of advertisement, you have to have a placement cost. It's regulated during the election period if it promotes or opposes a candidate or party, or it promotes or opposes an issue closely associated with a political party or candidate. I want to drill into what Elections Canada has interpreted those statutory terms to mean in the next couple slides here. So first of all, they've interpreted the provision promote or oppose a political party or candidate broadly. Essentially, if you name or identify a political party or candidate in any manner, it is regulated, and for the purpose of the Canada Elections Act, Elections Canada considers it promoting or opposing. So essentially, Elections Canada has interpreted that provision in the Act as identifying a political party or candidate. Importantly, at the very bottom there, it also includes advertisements that don't, in and of themselves, promote or oppose a political party, identify a political party or candidate, but they link to a website that promotes or opposes a party or candidate. So if you have advertisements, again, they don't have any images of a political candidate, they don't have any references to a political party, they don't refer to a political leader, it's a issues-based advertisement, for example, but you direct traffic to a website where those things are done, Elections Canada treats that as regulated. It's almost an anti-avoidance measure, if you want to think of it that way. What is meant by an issue closely associated with a political party or candidate? So I'd imagine the vast majority of the businesses and organizations on the presentation today are not looking to engage in overtly partisan activities, promoting a specific party, opposing a specific party, promoting particular candidates or leaders. But again, keep in mind, once the election is called, issues-based advertising is covered. The issue has to be closely associated with a political party or candidate, and Elections Canada has issued some guidance on that. A couple key points from that guidance. One, they've reiterated that it's up to parties and candidates to decide which issues are regulated. So if you want to know which issues are potentially regulated, you need to look at parties' platforms, at a leaders' debate, at an all-candidates forum, social media campaigns by local candidates, by the national parties. So essentially, it's again interpreted very broadly to include any public policy issues that federal candidates, leaders, or parties are talking about. Elections Canada has also clarified that if something isn't an issue at the start of the campaign, it's not being talked about, it's not closely associated with a party or candidate, but it becomes an issue later in the campaign, it can become regulated as of the date that it becomes closely associated with a political party. All that to say, the list of issues that are regulated, it's not static, it's dynamic and it's changing as we go through the campaign. There's a few exemptions from advertising, and the way the Act has been worded, these exemptions only are carved out from the definition of advertising. So they're not carved out from the next section we're going to talk about, which is partisan activities. But there's the transmission to the public of an editorial, debates, speeches, interviews, columns, commentary, or news. You can think of that as a news exemption or an exemption for earned media, as some folks refer to it as. There's an exemption for books. So if anyone on the call has written a book and they're planning to publish it, there's an exemption for that, provided it was written and was planned to be released prior to the election call. Importantly, I think for everyone on the call here, there's an exemption for groups, companies, unions that are communicating with their members, employees, or shareholders. So kind of internal communications at a corporation, at a union, or within a group are carved out from the definition of advertising. The fourth bullet is more for individual persons, but it's essentially meant to carve out personal communications on social media. On your personal social media, you are expressing political opinions. That's carved out from the definition. And as well, at the very bottom there, if you're doing get out the vote calls on election day or prior to election day, those are also exempt, but they have to be strictly get out the vote. You can't be tagging on, get out the vote because we've got to elect this party, or get out the vote because we've got to change the government. Those sorts of things could bring those calls within to a regulated sphere. So that, again, is the second category. So the first category was election surveys. They're regulated if they're used for a specific purpose. We then have advertising. It has to have a placement cost. It includes both issues-based advertisement and partisan advertising. There's exemptions carved out from that in the statute. The third category of regulated activities, the final category, is partisan activities. And this is kind of a catch-all category. I think of it as a catch-all category. It includes any activity or event that promotes or opposes a political party or candidate. So this includes telephone calls, robocalls, for example, sending emails or text messages, organizing a formal rally, for example, or some kind of event, again, where you're promoting or opposing a political party. Free, unpaid, unboosted social media can be covered under partisan activities, door-to-door canvassing. All of these sorts of things are captured by this third and final category. Importantly, and it's listed on the right-hand side of the slide there, this does not extend to strictly issues-based content. So again, if your phone calls or your rallies or events don't identify parties or candidates, they don't promote those parties or candidates, it's a strictly issues-based phone call, rally, event, it is not regulated. Okay, so it has to be partisan, as the name suggests. So that's the three categories again. If you engage in any of them and you exceed or you spend more than $500, incur costs of more than $500, you're required to register with Elections Canada and to abide by all of the labeling, spending, reporting, auditing requirements that are set out in the Canada Elections Act. The next part of the third party sphere that I'd like to talk a little bit about is the collusion and coordination rules, the anti-collusion and anti-coordination rules that are set out in the Canada Elections Act. And at their most basic level, these rules are designed to ensure that third parties are independent. Essentially, they work by themselves and they're not working with either political parties or other third parties. So third parties are meant to be independent. They're meant to have their own operations, their own strategy. They're not meant to be colluding or coordinating with other entities. There are restrictions that prevent, as I mentioned, third parties from colluding with political parties or candidates, including folks who are associated with those political parties or candidates. And there's also rules that prevent third parties from colluding with each other for a more narrow purpose of exceeding the expense limits. So essentially, you can't split yourself up into multiple little parties and then multiply your spending limit. You will be confined to spending one amount. So this would be really relevant for member-based industry association groups, for example, where you have member companies. Each member company can't go out and spend up to the maximum amount if they're all working together. If you work together with other third parties, you have to abide by one spending limit. Just to drill down on the associated persons, this will be really important. If you decide to engage in regulated activities or advertising, it will be really important that you wall off anyone in your organization who is associated with a political party or candidate. So that could include, for example, individuals, employees, officers, directors who are going to run for office. It could include partners of individuals who are going to run for office. It could include folks that sit on electoral district associations, people who are going to volunteer for campaigns, etc. So if you're going to engage in third-party activities or advertising, you need to ensure that the people who are making the decisions about that advertising or those activities are independent. They're not political. They're not involved in political campaigns. And the statute is worded very broadly when it comes to this prohibition. You'll see on the screen there, merely sharing information. So a third party sharing information with a political party, with a candidate or anyone associated with them, is enough to trigger that offense. So it'll be really important that you put in place appropriate ethical walls, conflict of interest guardrails, etc. And so with that, I will hand it back over to Guy to speak briefly about due diligence, and then we'll open the floor up to questions and answers. So if you do have any questions, feel free to drop those in the questions and answers box, and we'll get to those as soon as Guy's done speaking. Guy?
Yes, well, thanks. As Kyle said, I'll be very brief on due diligence. Next slide. Due diligence is something that is important because it protects you when things go wrong. Due diligence means taking all possible steps to ensure compliance. And that, as I said, in both an administrative proceeding or in a prosecution, that can work to your advantage to help you out in the event something goes wrong. Just the next slide. What does it mean to take all possible steps? Well, it means doing the things inside your company or organization to ensure that a later observer, could be the court, Commission of Canada Elections, somebody can look back and say, okay, well, that this organization did have all these measures in place. And what kinds of things? Well, Kyle just talked about. If you're engaged in third-party activity, you want measures in place to ensure that there is no contamination of your third-party activity from people who've got involvement with other third parties or with political parties or with candidates. We talked about election contributions. You're going to want to make sure that there are policies and programs in place inside your organization to make sure that employee time, company resources aren't being diverted to help parties and candidates. So the elements of due diligence include documenting what it is the expectations are, policy, having processes, protocols, steps in place that are understood to actually make sure what happens is supposed to happen or what is not supposed to happen is screened out. Once you've got a policy and a process, communicating that to your employees, so education, having people sign forms, training them like we're training today. It's not enough to do those things. You also have to have somebody whose role includes checking up to make sure that the things that are supposed to happen, and when they don't happen, there have to be consequences. Now, turning specifically to third parties, people often say, well, we're not going to do it. Whether you are going to engage in third-party activities or your plan for the election is not to, due diligence applies in either case. If you're going to register as a third party and you know you're going to engage in the regulated activities that Kyle described, then you should have a compliance plan to ensure that you are complying with the rules, you're registering, you're documenting your expenditures, you're reporting as required by law. If you don't want to, you also need a compliance plan. What does it mean for your business as usual communications? What does it mean for your advertising, your internet, your social media use, your posts? All of these things, if you've decided you're not going to engage in third-party activity, need to be screened pursuant to a compliance plan. So you need a compliance plan if you're going to do it. You also need we're not going to do it, and therefore for the duration of the election period, we're going to make sure we don't engage in regulated activities, compliance plan for those who don't intend to register as third parties. Which leads us to questions.
Okay, and there's already quite a few questions in the question and answer box there. Again, if you have any questions, feel free to drop them in there. So first question, Guy, and this relates to the lobbyist code of conduct and the political cooling off rules. If we are only canvassing a minimal amount of time versus being there every day or having a formal role in the campaign, will the political cooling off period still be triggered?
So the short answer is no, it won't be if it's minimal. But the commissioner of lobbying has actually identified that frequent, multiple canvassing can, of course, be taken as something that a politician would feel obliged about. And I'll add, just from experience, the different kinds of canvassing. Right. Kyle and I have both been involved in enforcement investigations where one of the questions was, well, did you go out with the candidate? Who'd you knock on doors with? And of course, logically it makes a difference. If the candidate knows you're there, if you're going door to door with the candidate, that's more likely to be seen to influence, right, create an unfairness than if you're just one of 100 people, the candidate didn't know whether you were there or not.
Next one, maybe I'll take this guy unless you wanna chime in here, but it's about election surveys. So they're in the third party advertising rules. The questioner notes that's correct. Would be great to know when they're included and what limits they create for anything. So again, surveys themselves are not by default regulated. So polls are not by default regulated. It's only if you use it for one of two specific purposes. So if you are a business or organization that's conducting routine market research, you're using that to monitor your business operations, for example, and you're not using it in any regulated activities, those polls or election surveys would not be covered. If you take any kind of polling, no matter when it was done, so it could be done before the election, again, about an issue, about parties, candidates, it's broad. And you use it, let's say, use an example, you take it to the board or you take it to an executive meeting, you lay it out, and then there's a vote on whether or not to engage in activities that is regulated, right? So that's the first test. It's used to decide whether to engage in advertising or activities or not to engage in advertising or activities. And the second one, again, is if you take that poll or that survey and you incorporate it into your advertising. So if you've done, for example, advertising on a specific public policy issue and you come up with data that suggests, X number of Canadians or X percentage of Canadians support a certain public policy issue, and you put that directly in your advertising, for example, then it's regulated. But if you're not using it for one of those two purposes, it's not regulated. So all of those polls, for example, that you see talked about in the conventional media on television, again, those polls are not regulated. It has to be used for a specific purpose.
I guess, Kyle, we should just maybe also, though, talk about, because it comes up from time. I don't know if the question was thinking about this. What about, giving a poll to a candidate or a party? So, do you want to talk about or should I talk about that? It
Yeah,
has
go
value.
ahead.
Yeah. So Kyle's looked at it from a third party perspective, but you always throughout the election campaign have to be thinking of third party rules and unlawful contribution rules. That polling has value. It's a thing of value. You've paid for it. And whether you've done it in-house with your own employees or you've actually contracted with a pollster, that has value. So taking that polling and giving it to a candidate or political party could be a non-monetary contribution. In fact, you should assume it will be an unlawful contribution. The next question often is, well, wait a minute, what if we're lobbying? We're trying to convince people to do it because it's popular. Well, that's a different story. But typically just taking the polling, which has value, and handing it off to a political operative is an unlawful contribution.
Yep. Yep, I agree with all that. The next one's interesting. So have there been any enforcement actions relating to the third-party election advertising rules since they were enacted? And Guy, I think they were enacted originally in their original form under Prime Minister Chrétien, if I'm mistaken. But do you want to talk a little bit about that? And then I'm happy to chime in as
So
well.
the short answer is yes, is the answer. The Commissioner of Canada Elections does absolutely pursue these. We've acted for people who've been alleged to have engaged in third-party activity. improperly. But I'll simply say we could probably put it in the chat. We can send people later. But it's actually quite well documented, quite posted. The commissioner routinely will either issue fines or, in fact, primarily you can expect to be fined if you've contravened the law. In a previous lifetime, I guess, years ago, you would have expected only to be sanctioned by having being asked to enter into a compliance agreement or an undertaking, which is kind of a naming and shaming punishment. And you'll see there are lots of entities that absolutely have we've found out and documented to have contravened those laws. But that was in the day before monetary penalties came into the fore. Now they've replaced them. So the answer is yes, lots.
Yeah, yeah. The only thing I'd add on that too is we're often asked, how do enforcement investigations start? And again, as Guy indicated, the Office of the Commissioner of Canada Elections is I guess aggressive regulator would be the term, and it's staffed by some extremely intelligent people, including a lot of retired RCMP officers. And again, they have very broad powers. Generally, though, in our experience, those investigations are started usually from tips or from whistleblowers. And we've done quite a few of these investigations over the years, but most of them are political parties reporting a third party, other third parties reporting a third party, activists reporting a third party, those sorts of things. Certainly the Office of the Commissioner of Canada Elections does monitor things, and they can initiate an investigation on their own. They don't need a complaint. But I think the vast majority of them are initiated from public complaints, which is, another reason to actually really drill down and ensure that you have a due diligence plan, especially if you're in an industry or sector that is, under a microscope. It's really important that you kind of close off any avenue by which someone could complain or allege that you violated the rules.
I guess, Kyle, we should also mention, by the way, that they've asked about investigations, but even before that, depending on the state your reports are in, you could find yourself subject to a very lengthy and difficult period of verification and a review by Elections Canada of your returns, and that's a thing that we walk through. And
Yep.
by the way, that could also lead to enforcement if you fail to give satisfactory answers and an accounting of what you've reported.
Next question is a really good question. So from a due diligence perspective, how do you determine, I think it's referring to a third party, could also apply to political parties, but a third party, how do you determine if they're spending what they're spending the money you've donated to them on? I'll maybe just take this one quickly, but I would say the safest thing is to build in contractual protections. So if you're going to donate money to a third party, there are requirements. For example, they have to identify you and all of that stuff. But you might want to set up a contribution agreement or some kind of legal arrangement whereby you specifically say what you want the funds used for. That will then give you remedies in a court if the funds are used otherwise. But it's a good question because you can never really guarantee what funds are going to be used for. And given the independence of third parties, once you kind of donate that money, you do lose a sense of control over how the third party actually spends it. So I'd say for that one.
Yeah, I would simply say, yeah, and we're happy to follow people individually, but
Yeah.
broadly, it's a thing that we're quite active in preaching. Our standard advice is that if you're going to give money to an entity and it's going to be doing anything in the public domain, whether it's holding an event, conference, advertising, that you should have election compliance language that you insert into that agreement, the anti-lobbying language that you insert into that. There's all sorts of political law implications of just giving money to another entity.
Yep. Okay, the next one. So can you confirm whether a public awareness campaign that is not political, but links to a Government of Canada website for more information would fall under regulated advertising? So I think the answer to that question is it really depends on the totality of the circumstances here, right? So again, if your advertisement, I mean, the link in and of itself isn't, the analysis doesn't rise or fall on that right? You'd first have to ask yourself, does it identify, promote, or oppose a political party or candidate? So if that public awareness campaign, for example, if the advertisements that are part of it or the paid social media that's part of it do any of those things, it would certainly be regulated. In terms of issues, again, you'd have to go to the test of whether or not it's closely associated with a political party or candidate. You'd have to look at their platforms, their social media, their speeches, those sorts of things to determine it. Um, so yeah, but happy to follow up with whoever asked that question. But really, it depends on kind of what exactly the advertisement is talking about and who it's identifying. So yeah. Um, okay, this is an interesting question. This comes up quite a bit. So what about publishing advertisements about topics that are part of the ordinary course of business, that are also part of political platforms, even if at a surface level? And then there's an example here, a company who has net zero goals and initiatives, and they advertise those. Would that count as advertising? Do you
Well,
want
so
to take that
yeah,
one, Guy?
I'd say probably not, but we have to look at everything in a case by case basis. So in its interpretation, I think, Kyle says Elections Canada is alert to the fact that there are some things that are so broad and universally accepted, they're not considered issues associated with the party. Like everybody's for, clean water, everybody's for good health care, everybody's for the relief of poverty. Everybody's for, promoting human rights and combating discrimination, just as examples among many things. So if we're talking about that, and I think I don't want to depends on the nature of your industry too, and depends on whether your industry is actually being talked about by political parties as they're campaigning. Generally, net zero, I think, would fall into the broad category. Everybody is for these goals, but um, again, every case it varies. I won't name industries, but there are industries, there are sectors of the economy that are actually singled out for attention during election campaigns. If you're one of those, that's a different story. What you say about how you're approaching these goals may or may not align or not align with what the parties are campaigning about. Kyle, would you add anything to that, or?
Yeah, I mean, the only thing I would add too is that, Elections Canada is probably going to look at the totality of the circumstances. So if this is actually an advertising campaign that's been going on for years, and as is noted in the question, it's the ordinary course of business, it's way less likely it's going to be regulated. Where you're going to run into some risks, or where the risks kind of escalate, is if, this was specifically planned for the purpose of an election, to be aired during an election. And again, keep in mind that the Commissioner of Canada election can look at things such as your board minutes. They can look at, internal memos that are prepared. So if the purpose of the campaign was business related, and the evidentiary record clearly demonstrates that, it's probably a lower risk. But I don't think the Commissioner of Canada elections would treat that as unregulated if it were designed for a specific election purpose. And I would also add, on top of that, if your campaign is referring to things like vote, or terms like vote or election, or those, like, and it's geared specifically towards the election, it's also more likely than not that it would be regulated. Yeah. But it's a good question to flag, and it's always good to evaluate these things prior to an election. And again, I think it's probably likely we're going on Sunday. So if you are contemplating these sorts of things, there's a few days, but not too many days to kind of plan in advance. So the next one here, you mentioned that in order to be considered partisan advertising, there needs to be a payment to the media, social media platforms, radio stations. Okay, yeah. If we're talking about an organic post on social media that does not cost anything, do we still need to account for overhead, staff prorated salaries, costs of software to develop images, etc.? Would these costs need to be included in a final report? Do you want to take that one, or do you want me to take that one?
Why don't you start with that one?
Yeah.
Because I think, and are we assuming partisan or issue based, Kyle?
Well, I'll maybe go through both. So for social media, you have kind of, I think of it as two buckets, right? So you have paid boosted social media, where you're actually paying a social media company to put your advertisement, your post, your tweet, whatever, into specific people's um, feeds. If you're doing that and it's either issues based or it's identifying, promoting, or opposing political parties, it's regulated. This question is talking about organic social media. So you're not paying to distribute that, amplify that. You just have, let's say, an organization or a business, you have paid media relations folks who are employees of your business or organization, and you just post content for free on social media, but you don't boost it. In that case, it really depends on what the social media is. So if it's strictly issues based, and again, you're not boosting it, it's just sitting there passively, it's organic, you're not promoting it, it's not regulated. So it wouldn't meet the definition of advertising because it doesn't have a placement cost, and it wouldn't meet the definition of partisan activity because it's strictly issues based. If, on the other hand, though, you post overtly partisan content, so again, you're a business, you're an organization, a union, whatever, and you post on your social media, it's time to defeat candidate X, or it's time for new government, or anything like that, it can be regulated as a partisan activity, not as advertising, because it doesn't have a placement cost, but it can be regulated as partisan activity, and you would have to include the staff time. So if you have, again, paid media relations folks who are developing overtly partisan content, you just push it out for free on your social media, you would potentially have to register. And certainly if you spend over, incur costs over $500, you'd need to value that. I don't know if you have anything to add on that, Guy. Um, okay, so the next question here, I understand that third parties would be treated as entities analogous to parties and candidates. This means they would need to set up bank accounts through which to finance regulated activities. Could you enlarge on this? Yes, that's absolutely correct. We didn't go through all the steps. Again, if you're thinking about registering as a third party, we're happy to help you through that process, but you're correct. You have to open up a separate bank account. Your contributions from eligible contributors or your own source funds you're using have to be deposited into that account. There's labeling requirements, there's auditing requirements, there's reporting requirements, all that stuff. One of the other things you'll need to do sooner rather than later, in addition to opening up a bank account, is you need to get board approval to engage in regulated activities or advertising. So if you're going to do this, you can't just, if the election's called on Sunday, you can't just start on Sunday or Monday. You have to get board approval before you can start engaging in regulated activities. I don't know if you have anything to add on that, Guy.
No. Actually, just curious, would you want to drop the slides though while we do our Q&A? Probably.
Yeah, sure.
Yeah. There we are.
Okay.
This is
There
what we
needs
look like in bigger full frame or half frame.
There needs to be payment to the media that broadcasts an advertisement to be considered partisan advertising. What about organic posts on? Okay, so I think we covered that with the organic posts on social media. So again, organic, free, unboosted social media can be covered if it is partisan. And yes, you would need to account for that. Then we have one more question on social media. I think we got into that. Okay, one of the submitted questions in advance here, Guy, is it hypothetical? There's a hypothetical here. So could you hypothetically repeal the fixed election date law and have an election later than October?
Um, Well, I guess yes. If Parliament was sitting, yes. In theory, that is possible. So there's a 5 year. There's actually not a requirement that elections be held. Sorry, there's a requirement that elections be held every 5 years in the Constitution Act. And that Parliament sit at least once a year. So it is possible to repeal the fixed date election law. I don't see that happening, and only Parliament could do that. But yes.
Okay. Listen, we're just about at time here, but Guy, did you have any kind of closing messages or anything?
Well, just no closing messages. There was a question I did want to address that had come up just yesterday somebody had asked. A group had been collecting signatures and names and addresses of people who were supportive of an issue, and the question was, can we hand this over to a candidate who is shares our issues? And I think the answer to subject to privacy laws, which may apply to you, for example, PIPEDA applies to your commercial activities. That is, but to comply with privacy laws. But in addition to that, the answer comes down to value. If you're giving a thing of value, and there is value in data, there is value in names and addresses, and you're not a human individual, you are an entity, then you can't give anything of value to a party or candidate. So no, you can't give your list of names and addresses of supportive people to them. You can give anything of value. But other than that, I think I want to thank people for their time. We appreciate that you've logged in today. It's a complex area. It's an important area. It's an evolving area. So we appreciate this. We also, our last point is you will receive a feedback request. Kyle and I and everybody at Fasken, we rely on these to improve, change, tailor how we present these in future. So we appreciate the time you've devoted this morning, but we do also, I want to thank you in advance for spending maybe a couple extra minutes just to give any feedback that'll help us to deliver content like this in future.
All right. Thanks, everyone. Have a great day.